Avoiding business litigation can save you time and money while still resolving issues. In Oklahoma, many businesses can avoid the time, cost, and public exposure of court proceedings by using alternative dispute resolution (ADR) methods. Whether you're dealing with a contract issue, partnership disagreement, or vendor conflict, understanding your options outside of the courtroom can save your business money and preserve important relationships. Why avoid court in business disputes? Going to court can be expensive, time-consuming, and unpredictable. Business litigation often involves extensive discovery, attorney's fees, and months or even years of delays before reaching trial. Additionally, lawsuits are public record, which can damage reputations and strain professional relationships. For many Oklahoma businesses, pursuing resolution outside of court provides a faster, more flexible, and often more private path forward. Common alternatives to litigation in Oklahoma. 1. Negotiation. Negotiation is the simplest and most direct way to resolve a dispute. This informal process allows the parties to communicate directly or through their attorneys to reach a mutually acceptable solution. It often helps preserve business relationships and can be used at any stage of a disagreement, even before a formal complaint is filed. 2. Mediation. Mediation involves a neutral third party, called a mediator, who facilitates discussions between the parties and helps them find common ground. The mediator does not issue a decision but guides the process to promote compromise. In Oklahoma, many contracts include a mediation clause, requiring the parties to attempt mediation before filing a lawsuit. Mediation is commonly used in contract disputes, construction disagreements, employment claims, commercial lease issues. If mediation succeeds, the agreement can be formalized in writing and enforced like a contract. 3. Arbitration. Arbitration is more formal than mediation, but still occurs outside of court. The parties present their case to a neutral arbitrator or panel who issues a binding or non-binding decision depending on the terms of the arbitration agreement. Many Oklahoma business contracts contain arbitration provisions. Arbitration can be especially useful in complex contract disputes, business-to-business claims, cross-border commercial disagreements. Arbitration proceedings are typically private, faster than litigation, and less costly. 4. Settlement conferences. Sometimes the parties can resolve a dispute through a settlement conference, which may be court-ordered or voluntary. These conferences typically involve attorneys and a judge or magistrate who help the parties evaluate the strengths and weaknesses of their case. Settlement discussions often lead to resolution before trial. Using contract clauses to avoid court businesses can proactively reduce the risk of litigation by including dispute resolution clauses in contracts, which may require mediation or arbitration before any lawsuit, designate the governing law and venue for disputes, establish timeframes for resolving conflicts. Having clear language in your contracts can make it easier to enforce alternative dispute resolution, ADR, and avoid unnecessary court filings when litigation becomes necessary. While ADR works in many cases, some business disputes still require litigation, particularly when a party refuses to participate in good faith. The dispute involves fraud or illegal conduct. Arbitration or mediation has failed. When that happens, having experienced business litigation counsel is essential.